In a 6-3 decision, the United States Supreme Court has just ruled in favor of Donald Trump, saying that Donald Trump has absolute president immunity for crimes committed that can be considered official acts. The right-wing supermajority in that 6-3 decision not only gave Donald Trump what he wanted, but in fact went even further than what Donald Trump was asking for, saying that Trump has absolute immunity for official acts, and then that a president who can claim that their conduct constitutes official acts cannot even have those acts used as evidence in other proceedings at all. Here's what Mark Joseph Stern says. He goes, "Today's decision is about as big as a win for Donald Trump as he could have possibly wanted for or expected. The conservative supermajority creates a sweeping new kind of presidential immunity that will insulate many of his allegedly criminal acts from indictment or prosecution." For Donald Trump, this is exactly what he was asking for when he says he can order SEAL Team 6 or the military to kill his political opponents, and that would be considered an official act that now would be subject to absolute immunity. You know the severity of this ruling from the dissent and the three appointees from Democratic administration, Justice Sotomayor, Justice Kagan, and Justice Ketanji Brown Jackson, wrote about as grim and as dark and as frankly terrifying of a dissent as I've ever read in the history of the Supreme Court. Justice Kagan signs off on her dissent with saying, "With the fear for our democracy, I dissent." And this is what Justice Sotomayor states. She goes, "Looking beyond the fate of this particular prosecution, the long-term consequences of today's decision are stark. The court effectively creates a law-free zone around the president, upsetting the status quo that has existed since the founding. This new official acts immunity now lies about like a loaded weapon for any president that wishes to place his own interests, his own political survival, or his own financial gain above the interests of the nation. The president of the United States is the most powerful person in the country and possibly the world. When he uses his official powers in any way under the majority's reasoning, he now will be insulated from criminal prosecution. Ordering the Navy SEAL Team 6 to assassinate a political rival, immune. Organizing a military coup to hold on to power, immune. Taking a bribe in exchange for a pardon, immune, immune, immune. Let the president violate the law. Let him exploit the trappings of his office for personal gain. Let him use his official power for evil ends, because if he knew that he may one day face liability for breaking the law, he might not be as bold and fearless as we would like him to be." That is the majority's message today. Even if these nightmare scenarios never play out, and I pray they never do, the damage has been done. The relationship between the president and the people he served has shifted irrevocably. In every use of official power, the president is now the king above the law. That the Supreme Court has just anointed the president as the king. Then you had Justice Ketanji Brown Jackson in her dissent saying the same thing, that the majority has just said that when Donald Trump's in office, or any president at that matter, has king-like power, is not responsible to we the people, and all they have to do if you're in office is claim that your conduct is an official act, which the Supreme Court gives broad latitude, broad presumptions of what constitutes an official act, and you get absolute, total immunity from any conduct at all. Popak, this decision from the standpoint of our democracy, I don't want to sugarcoat it. I don't want to mince words, because this could not be worse for our democracy, and everything that Donald Trump wanted and more, they've essentially given him. The right-wing Supreme Court here. What's your take on this?
We can't blow sunshine here. It severs the relationship between the presidency and making him be respectful and beholden to the people that put him into that office. It changes the balance of power while claiming that it's merely reinforcing a separation of powers, which was repeated time and time again by Chief Justice Roberts, joined by his 5 other right-wing MAGA Supreme Court justices in the ruling. They're just saying it's just about separation of powers. But it used to be a co-equal branches of government, checks and balances on each other. That has now been destroyed by the way they've categorized the 3 types of conduct that they're now going to require all trial courts, including Judge Chutkan, who's been patiently waiting along with our democracy for the results of this decision, rendered on and dropped on the last day possible, leaving absolutely no time to put this trial on. There's now 3 categories of conduct that have to be evaluated by a judge in looking at an indictment. And then I'm going to tell you quickly which of the ones already in the indictment are out completely from the 4 different categories of behavior that the Donald Trump was indicted for. Firstly, if we're talking about things, there's a subset of conduct or powers, if you will, of the presidency, which we usually refer to as core presidential powers. They are literally expressed in the U.S. Constitution: the power to appoint, the power to remove, the power to conduct foreign policy. The things that are expressed in the Constitution, those core presidential powers have now been, if the indictment relates to those and the conduct there, that is absolutely immune. Now, many of the things in the indictment do not relate to the core presidential powers as I just laid them out. But then they then said there's a second bucket. The second bucket is official conduct. Doesn't go as far as being from the literal text of the Constitution, not core presidential powers, but official conduct. And that's going to be given a presumption of immunity that is very difficult to overcome. And a trial judge is going to have to evaluate whether the conduct that's being indicted, if prosecuted, would rise to the level of improper interference with the executive branch. And if it does, the phrase is danger of intrusion on the authority and function of the executive branch. And if it does, the presumption cannot be overcome and immunity is given for official conduct. Now we're down to unofficial conduct, not private conduct, but unofficial conduct. And if it's unofficial conduct, right, then there is no immunity and there's no presumption of immunity. And therefore, you got to figure out which of the things in the indictment, for instance, in the Jan 6th election interference case in the Washington, D.C. and in Georgia, because that would apply there too, which of that falls into this third narrow bucket of unofficial conduct. And that has now been remanded back to Judge Chutkan for the case that's at bar right now to determine which of the elements of the indictment could fall into this narrow shot glass of a category of unofficial, not official, not core presidential power. And only that can be indicted. And to help her do her job, even though they said in the opinion that it's not for them as an appellate court to prepare a record, they told her straight out what her instructions are. As it relates to the interference, the criminal conduct of Jeff Clark and Donald Trump at the Department of Justice to try to influence the outcome of the election through improperly weaponizing the Department of Justice, that is immune. Take Jeff Clark, take everything about the Department of Justice off the table. The interactions between Donald Trump and his minions with the vice president, meaning the pressure campaign on Mike Pence at the heart of the indictment, is off the table. It's been declared immune. Now you're left with Chutkan having, when she gets the case back in the next couple of days, having to determine if the interactions with the election officials and elected officials would constitute unofficial or official conduct. She's going to have to do that at a hearing before she can even let this indictment go forward. And I'll leave it on this, Ben, for my part here. If you thought this was as our producer said, was we were getting ready for this, a wrecking ball to both the Constitution, the separation of powers, and a win for Donald Trump, there's more. Clarence Thomas not only did not recuse himself, he wrote a concurrence written directly and addressing directly Judge Cannon in the Mar-a-Lago case, because he says in the first page of his concurrence, I don't think the special counsel is legitimate. I think he was illegitimately appointed, and there was an illegitimately appointed special counsel, a private citizen without constitutional authority or delegation, who's prosecuting the president. That is exactly the issue that is before Judge Cannon right now, and now has just gotten renewed support from a Supreme Court justice in the majority, basically saying the special counsel was illegally prosecuting this case against Donald Trump.
And Popak, what the majority declares as well, and this is what Justice Sotomayor says in her dissent, the majority has also declared that evidence concerning acts for which the president is immune can play no role in any criminal prosecution against him. That holding, which will prevent the government from using a president's official acts to prove knowledge or intent in prosecuting private offenses, is nonsensical. So when you are trying to show, so finally, in that small group of what could be now considered unofficial acts, let's say it's not a core president. Let's talk about the January 6th case. So we're not getting into hypotheticals, right? Clearly leading an insurrection. You can say that's not a core presidential power. What he did on the ellipse is not a core presidential power. Trump next will then argue, well, this falls under the official conduct. I was doing my job to try to find fraud, is what Trump will argue. And we'll all say, that's ridiculous. That's not what you were doing. You were trying to overthrow a free and fair election. And then Trump will say, I'm entitled to a presumption. I get this presumption now that the Supreme Court says. So let's assume you get over the presumption, right? And then it's deemed an unofficial act. Well, then how is the prosecutor going to prove the crimes where you can't use any evidence? His conduct as related to the vice president, his conduct with the DOJ, all of his other acts for which the Supreme Court has now given him absolute presidential immunity, it's gone. You can't use that as evidence in the prosecution itself based on this.
So you're saying, and you're right, that if they're leaving it where the Jan 6th events themselves, from ellipse to attack, have to be now evaluated completely unmoored and untethered to all of his prior conduct. It has to rise and fall on its own, and then determined by Judge Chutkan at a district court hearing to determine whether any of that will fall into unofficial, unprotected, no immune conduct. Crazy.
Well, and then think about this, and we'll do another hot take on it. To the extent any of Donald Trump's mens rea or mental state was used in the Manhattan District Attorney criminal case, like when Hope Hicks was brought in, his communications with her when he was in office, how he would send letters while he was in the White House, right? Because what they're saying here is that evidence concerning acts for which the president has now been given this sweeping immunity, that cannot be used at all in any other proceedings. And that's not me saying it. That's what Justice Sotomayor is saying.
And there's a twin there. There's the other side of the coin. Motive cannot be evaluated for determining whether this former president or the next one committed the crime or not. You can't look even if they don't even care about mixed motive. No motive can be evaluated. That's how much immunity they're putting the presidency up, not only on a shelf, as you said, they're putting him well above the law, which is Sotomayor's poignant but totally dystopic dissent.
Yeah, and that's why she says, for fear of our democracy, I dissent. That's not a normal way a dissent ends right there. And again, this is not something that we can sugarcoat here. You may hear other analysis elsewhere, people saying, well, can't this fall into an unofficial act? And therefore, this should be good, right? If you just listen to how we broke down that analysis and what Justice Sotomayor
waterfall, it ends up in a shot glass at the end.
Says in the dissent. I mean, that's why we, the people, need to really understand what's up right now. I could never have, I think, fathomed the United States Supreme Court saying that, you know what, just totally screw the law. There is what's called a king. And I guess this conservative movement has actually not been conserving our democracy, but what they really wanted to conserve was the monarchy. Look, Michael Popak and I will break this down and we'll go into it in lots of other ways, but that's our initial hot take, having read the opinion, the concurrences, the various dissents right there. We'll be back with more. And I do just want to let everybody know, though, we're in this together. Okay. At the end of the day, while this decision is grim and bad, horrific, not panicked, I'm motivated right now, and I'm motivated to determine what we, the people, can do. And I think that's how we all need to feel. Hit subscribe. Let's get to 3 million subscribers. Right now, we'll be back with some more updates soon. Thanks for watching.
Love this video? Make sure you stay up to date on the latest breaking news and all things Midas by signing up to the Midas Touch newsletter at MidasTouch.com/newsletter.